Good morning. Again, a turning judgment, reverse judgment about issuance of community certificate for particularly scheduled caste, scheduled tribe. This judgment deals with affinity test, a test being applied for issuance of community certificate. AIR 2023 Supreme Court 1657, AIR 2023 Supreme Court 1657, Maharashtra Adivasi Thakur Jamaat Swarakshan Samiti versus State of Maharashtra. There, the division bench, two division bench of the Supreme Court had different views. In Vijay Kumar versus State of Maharashtra, they say if a candidate fails the affinity test at any stage, caste validity certificate cannot be granted to him. Then again, Anand versus Committee for Scrutiny and Verification of the Tribe Claims, it was held that the affinity test is not only criteria for deciding caste claim. Therefore, these two judgments were referred to full bench judgment. So they have categorically discussed how community certificates are being issued. Number one, these all are the information for all. The inclusion of the scheduled caste tribe is under Article 342 of Constitution. That should be kept in mind. Then there was a application for grant of social status certificate shall be made to revenue subdivisional officer and deputy collector or deputy commissioner, and the certificate shall be issued by such officer rather than at the officer taluk or mandal level. This is what they say. Then there shall be scrutiny committee which consists all the state government shall constitute a committee of 3 officers, namely additional or joint secretary or any higher officer rank of the director of the departmental concerned. This is what they say. Then see, other procedures are there, you go through that. Then I want to share another area. The applicant must certificate the following certificate according to Rule 11 and Rule 2 under Act 2000. You see, this is what they say. Applicant shall submit the following documents with this application for verification of a scheduled tribe certificate. Original documents, original scheduled tribe certificate of the applicant along with one attested copy, an affidavit in Form F, documents of which only attested copies are to be submitted in respect of applicant, primary school leaving certificate, an extract of school admission register, an extract of birth cert register, document in respect of father, an extract of birth register, primary school leaving certificate, extract of school admission register, scheduled tribe certificate. If the father is in service, the extract of pages of the service record which contains religion and the tribe re-entry. If the father is illiterate, the primary school leaving certificate of the real elderly blood relatives of the paternal side of the applicant, extract of school admission register. Other documents. Revenue records like birth register, extract 7/12, sale deed, etc. Any other relevant document in support of his scheduled tribe claim. Affidavit of the near relatives whose validity certificate are submitted in support of the claim. Applicant shall submit original certificate and documents for verification. These all are the things. Now, what was the dispute? They say that is most important. This is what the they say what they say. The affinity test is not litmus test to decide the claim, because they say But to what was the affinity test means, you have to substantiate what all are your uh, mm, procedures, your marriage particulars, and how you claim these things should be there. They say, actually, I would like to read that most important area. Uh, if a person hails from other district, other his tribal area to urbanized area for years together or decades together, he may not be in a better position to submit the answers for this affinity uh, procedures, affinity certificate, affinity certificate. That's what they say. Uh, Finally, they come to conclusion that if all the certificates are verified according to the direction of the certificate scrutiny committee, if they are not satisfied, then they may refer to vigilance cell. Then vigilance cell may go through the inquiry, and then they need not take this affinity test. If suppose certain documents are there, and this affinity certificate may be used for some additional evidence, but affinity test alone shall not be the ground for issuing certificate. They say the vigilance cell, while conducting affinity test, this is most important test, verifies the knowledge of the applicant about deities of the community, customs, rituals, mode of marriage, death ceremonies, etc. in respect of particular scheduled tribe. By its nature, such an affinity test never be a conclusive. They say if the applicant has stayed in a bigger urban areas along with family for decades, or if a family has stayed in such area for decades, the applicant may not have knowledge of aforesaid facts. But on contra, they say a person may not belong to particular tribe, but he may have good knowledge about the aforesaid aspect. So these things are there. Therefore, finally, the Supreme Court has held that the affinity test need not be there. Affinity test need not be ground for either accepting, issuing community certificate or cancelling the community certificate. Therefore, kindly go through the judgment. This is most important judgment. This is not only for scheduled tribe. You can also apply the judgment for scheduled caste community also. And this is what my humble submission is. And finally, I would like to say that the all fishermen of entire coastal areas of India, Tamil Nadu, particularly Andhra Pradesh, Orissa, West Bengal, Kerala, Maharashtra, Goa, Gujarat, they must be considered as a scheduled tribe only, because all these scales being applied to scheduled tribe, they have their own deities, they have their own language different from the language being used in the other than the area of seashores, and they have their habit of food is also different. So many things are therefore. So always I used to say the fishermen leaders must fight for inclusion of fishermen as scheduled tribe, because you leave other fishermen who are mingled with other communities, but the fisherman who was habitually living with permanently living with fishing business or profession, whatever it may be, avocation, and not even settling other than the seashore area, or must be considered as a scheduled tribe. That's what my humble submission. And somebody should take steps for these things. Best wishes.